Yeah.
Thank you, Mr Deputy President, and I rise tonight to speak against the Industrial Relations Amendment Industrial Court Bill 2016. And before beginning my contribution, I just wanted to pay tribute to the Honourable Adam Searle, who led for the opposition, and as the Shadow Minister displayed an extensive knowledge in this area with his thoughtful and insightful contribution as a practitioner in the area and now as a lawmaker as well. Now, as he outlined, the opposition is strongly opposing this bill because the bill abolishes the Industrial Court of New South Wales, seeks to transfer its functions to the Supreme Court and make consequential changes to the Industrial Relations Commission of New South Wales. Now, Mr Deputy President, you do wonder whether the government is either out of touch or on a blind ideological pursuit when it outlines its position today, and I would argue that it's the latter. There is a recognition that in certain parts of the legal system that it needs to be more accessible for the average person, whether that's in consumer law, but perhaps in other areas, but it's certainly the case in industrial law, where we're dealing with the rights of working people, sometimes some of the most poorly paid working people, and their access to justice. And tonight, instead of making that more accessible for working people, the government is seeking to push it further out of reach. Now, the bill seeks to abolish one of the key institutions that has historically protected working people in this state. And on this side of the House, we are incredibly proud of that long history that dates back to the 1900s. It's a core premise of the Australian fair go that the average person who turns up to work, if something happens, that they have access to legal redress. Legal redress that is not difficult or expensive to access. It does not require barristers or solicitors, but allows them to participate in a court of law and advocate on their own behalf if required. Now, of course, with the latest round of federal industrial relations laws, the modern awards, as they are known, there has been a centralisation of the system into the federal system. But the sole justification for this legislation, for abolishing the Industrial Court and stripping the provisions for the Industrial Relations Commission, is because it doesn't have enough work to do. Well, Mr Deputy President, the reason why it has happened is because of the ideological drive of those opposite, to strip away the work of the important work of the Industrial Court. Now, this bill tonight will no longer give working people that access to a specialised court that allows them to pursue redress on a range of matters, whether that's breaches of industrial instruments, recovery of wages, unfair contracts, regulation of unions and employer organisations, superannuation appeals and violation of dispute orders. Now, Mr Deputy President, if you're a wealthy company that is well attuned and regularly in the courts, or equally you're a well-resourced employer organisation, then whether you're filing in the Supreme Court or in the Industrial Court, then it won't make a great amount of difference. But if you're a small individual worker, if you are a small trade union, or if you are a small business, you are pushing them into a court of law that is not designed to be accessible for them. Now, this is obviously something that we have seen by this side, by that side of politics, pursued at a federal level for a long time. We saw it pursued through the Workplace Relations Act at a federal level in 1996, where they sought to push industrial relations into the federal court, out of the Industrial Relations Commission at a federal level, and now we're seeing the same thing happening here at a state level. And it is absolutely appalling because it gives no improvements for individual participants. It gives no increased access to justice for them, and as I said earlier, no better outcomes or easier access to redress for individual workers, small business or small trade unions. This is a very, very significant change that we are debating tonight. For example, let me illuminate this. To make exactly the same application as under the existing rules into the Industrial Court, it will be almost $200 more to make exactly the same application into the Supreme Court. Now, that might not be much, if you're a large, well-resourced company. But when you're an individual worker who is seeking recovery of wages, acting with perhaps their trade union acting on their behalf, or maybe acting for themselves, where are they supposed to find that over $1,000 to stump up to seek to get that money from? It's making the process more formal, it's making the process more legalistic, and it's losing those specialised functions that have been developed over the last 120 years almost through our Industrial Relations Court. As outlined earlier, in the industrial court you can move in and out of arbitration and conciliation. You can allow the parties to come together to negotiate, enter back into the courtroom and then negotiate further if required. But this legislation is instead saying no, we want to fight it out in the Supreme Court with barristers and solicitors at 100 paces. I mean, the fact that there is no improvement for individual participants, but on top of that, that there's no improvement in the bottom line for the government. It's simply transferring judges from the industrial court to the Supreme Court. It really does beg the question about why we are here debating this tonight. And I refer back to my earlier comments that this is a blind ideological pursuit, not one that is aimed at seeking better outcomes for workers, seeking better outcomes for small business, or seeking better outcomes in terms of accessibility of justice. Now, as other members have reflected, the government did attempt some level of consultation on this and provided draft legislation to stakeholders in August, but at the close of submissions failed to make these public. So the opposition does understand that these submissions overwhelmingly oppose the changes that we're debating today. And I'd refer to some public comments made by Alex Grayson of Maurice Blackburn Lawyers, who said she was concerned about the access to justice that it would diminish under the new arrangements. It is more intimidating and costly for employers and employees to access litigation in the New South Wales Supreme Court. And I think that this is an important point to make. The point about intimidation is one that we shouldn't gloss over lightly. The average worker, the average person does not have frequent interactions with the legal system in New South Wales. The average person would only go there as a last resort. And it is our duty, I believe, as policymakers to allow that process to be as easy as possible. Now, in other areas of law, as we've reflected upon, sometimes that means making it into a less formal tribunal setting for areas of consumer law and anti-discrimination law and other areas. This was something that we have pioneered in this state and in this country over the last, like I say, almost 120 years. And now tonight we seek to walk away from that entirely. And I think that the legacy for working people in New South Wales is a real shame. Now, as I outlined, we will be opposing the bill tonight, and I think it's important just to reflect upon what our election policy at the last election was, which was determined to be revenue neutral by the Parliamentary Budget Office. This is not a question of a more efficient allocation of government savings. This is a question of how you prioritise the fate of the average working person in New South Wales. And we on this side are very proud to stand up for those average working people. We would seek to rebuild the court and reinstate the work taken away from it by this government, investing it with relevant legislation under New South Wales law, allowing this specialised field of law, allowing this specialisation to prosper. And Mr. Deputy President, that is so important to allow that area of specialisation, the accessibility by individual workers, by small trade unions, by small business, and by workers generally to have access to advocate in an efficient but in a specialised setting that makes it easy for them. Mr. President, I want to pay tribute to Unions New South Wales for their unending advocacy on behalf of the working people of New South Wales, and I would also like to, and I will say that we will be opposing this bill, and I call on other members of this place to do so as well.